Hello guys, I hereby welcome you once again to the Samuel Law podcast and Academy YouTube practice. After going through the introduction in our module 1, today in our module 2, we are going to look at one of the branches of law, which is criminal law. Welcome. Now in criminal law, the objectives that we are going to walk through in this module is the definition of what criminal law is. We are also going to identify the different terminologies applied to criminal law, understand the different types, identify the different elements of a crime, also understand the different types of actus reus, learn about the different factors that inform the element of a crime, identify the defenses that negate the actus reus of a criminal offense, and also understand the coincidence that the correspondence that must exist between the actus reus and the mens rea for one to be held criminally liable in an offense. Introduction. Criminal law generally refers to that branch of law that protects the rights and obligations of individuals in a society or community. The types of conduct which are considered to be criminal vary from society to society. For example, we have issues like offenses like homosexual, wife raping, etc., which to some societies they are criminal, but others they are not taken as criminal offenses. This variation therefore means that there is no absolute definition of criminal behavior, since what may be considered by many in a society as antisocial may not be criminal, may necessarily be criminal, whereas some behavior which may affect nobody but those participating in them are considered to be criminal offenses. We can take an example of smoking cannabis or maybe failing to wear a seatbelt while in a moving vehicle. Let's look at the elements of a crime. For one to be held criminally liable, his acts or omissions must be accompanied by a guilty mind. In Latin, this is what is known as actus non facit rem nisi mensit rea, which brings us to the two elements of a crime, and that is actus reus and mens rea. Let's begin by looking at the actus reus of an offense. Actus reus simply means that guilty act or conduct of the defendant. It comprises all the external elements of the offense other than the mental factor or the state of mind of the defendant at that particular moment. Conduct of the defendant must be voluntary for the defendant to be found guilty of a crime. And the proof that is needed here is that of beyond reasonable doubt. Let's look at the types of actus reus. Crimes can be divided into three types depending on the nature of the actus reus. One, we have the action crimes. In action crimes, the actus reus is simply an act. That particular act, the consequence of the act being irrelevant or immaterial. We can take an example of perjury, whereby somebody makes a statement under oath, knowing for sure that statement is not true. So, irrespective of whether that statement might make a difference in trial, does not affect the fact that already the act has been committed. It does not negate the fact that perjury has already been committed. In our second one, which is the state of affairs crimes, here now is the complete different of what action crimes are, because in state of affairs crimes, the actus reus now consist of the circumstances and maybe even the consequences, but no action or omission is necessary. It actually creates an exception to the principle of voluntariness, as they are being rather than doing offenses, hence conferring absolute liability on the defendant. The third one is the result or conduct crimes. The actus reus of this is distinguished by the fact that the accused's conduct or behavior must produce a particular result or outcome. An example here is the case of murder, where the defendant's act must actually cause the death of a person. The result must be so specific. It must be proven beyond that it is the defendant's act that actually caused the death of that victim. Now, this result crime, it raises the issue of causation, which can simply be defined as a set of rules used by the court to determine whether the defendant's conduct can be regarded as the legal cause of a particular result. Just as I've been saying, the result must be proved to have been caused by the defendant's act for him to be held liable. The defendant will not be liable if the result is caused by an unforeseen intervening act or event, and which is completely independent or unconnected with the defendant's act. However, when the result is caused by a combination of the defendant's act and the intervening act, but the defendant's act remains a substantial cause, then he will still be held liable. We also have omission. At common law, criminal liability is rarely imposed for true omissions. However, there are some situations that the accused has a duty to act, thereby creating liability for a true omission. A duty to act will only be imposed where there is some kind of relationship between the parties. And the closer the relationship, the more likely it is that the duty to act will exist. Let us look at some of the examples that such a duty to act really exists. We have factors or situations that may give rise to a duty to act, and they include where there is a close relationship between the parties, just as have been mentioned above. We also have where there is a voluntary acceptance of responsibility for another. Thirdly, we have where there is a contractual relationship, and also where there is a duty imposed by a statute, and also where the defendant has created a dangerous situation. Defenses that negate the actus reus. Here we have justificatory defenses, and this negates the unlawfulness of the actus reus, thereby making it seem as though no crime at all has been committed. They can be used where an offense has been committed in morally justifiable circumstances. And we can say the examples here include maybe self-defense, consent, and even necessity. We also have excusatory defenses. This excuses fault or mens rea, thus relieving the defendant from any liability because he lacks responsibility, even though the actus reus cannot be denied. They can be used where the defendant commits a crime under excusing circumstances for which he is not responsible. The emphasis that is here will be on the state of mind rather than the circumstances that have led to that. And they include maybe working under duress, insanity, automatism, and even a mistake. Mens rea. After going through the actus reus, now let us look at the mens rea, which is another element of a crime. Mens rea simply means a guilty mind in Latin, and it generally refers to the state of mind of the person committing the offense or crime. To better understand mens rea, we need to refer to the difference between subjective and objective tests. Under subjective test, we actually look at what the defendant was thinking at that particular time that the offense or the crime was being committed. Whereas objective tests looks at what a reasonable person would have thought were he to be in the position of the defendant. The required mens rea varies depending on the nature of the offense, but there are two main states of mind elements, and that is intention and recklessness, which either separately or together can constitute the necessary mens rea of a criminal offense. So let's look at the first one, which is intention. This is a subjective concept, which is the highest form of mens rea and also the only mens rea requirement for offenses of specific or ulterior intent. Intention can be divided into either direct intent or oblique or indirect intention. Direct intent is where the consequence or result of an act is actually desired, while oblique or indirect intent refers to a result which is not desired but which is either a prerequisite to the defendant's primary purpose or one which is virtually certain to occur as a consequence of his act. Recklessness. This is defined as the conscious undertaking of an unreasonable or unjustified risk of harm. It is a definition of mens rea found in crimes of basic intent. To be reckless, one definitely needs to be aware of an unreasonable risk of harmful consequences. Liability depends on foresight, which is the conscious taking of unjustified risk. After these two, we can also look at negligence, which has been used by many as to mean recklessness. But here we now want to see the difference between negligence and recklessness. Negligence is defined as an unreasonable conduct which creates an obvious risk or harm or damage through genuine inadvertence. Risk may never have entered the mind of the defendant at all. Negligence is not a form of mens rea, as it does not relate to the state of mind, but to unreasonable standard of conduct, which in ordinary language can be called as stupid, inadvertent, an error of judgment, or simply a mistake. Negligence generally falls outside of criminal liability, as it is a form element of civil liability, which involves cases such as road accidents and personal injuries. After going through that, now let us look at the recap of what we've just learned in our module 2 today. So in this module, we have been able to 1. Learn the meaning of criminal law, define and understand the elements of a crime, learn about the different types of actus reus, We have learned about the factors that inform the actus reus of a crime. We have also learned about the defenses that may negate the actus reus. And finally, we've also have been able to understand the factors that may constitute the necessary mens rea of a crime in that nature. Thank you very much for watching. See you in our next module. Do you have any questions or comments? Please kindly post them in the comment section below the video. Otherwise, thanks for watching this video. Please remember to subscribe to my YouTube channel, like the video, click the notification bell, and share with your friends and family or networks. Thank you.